Good evening, dear participants. We are very pleased to welcome you today at our joint event of the Ukrainian Arbitration Association and ICC Ukraine. This event with Gary Bourne regarding the topic of reparations, or rather, how to make Russia pay compensation to Ukraine. Our speaker today does not need any introduction. And the event will be moderated by Anna Giyard, board member of the Ukrainian Arbitration Association, and myself, Olena Pripolinska, president of the Ukrainian Arbitration Association and chair of the Arbitration Commission of the ICC Ukraine. So, with regard to some technicalities, the questions could be asked using YouTube comments function. As always, we will follow the comments and will pick up questions in the end of our discussion. The topic of today is really important for Ukraine. So we know that on 24th of February, our life has changed in before and after. And we are all want to win as soon as possible, but in addition, we want to help Russia liable for all it has done to Ukraine. And of course, the topic of reparation is widely discussed in different levels by different state officials. And all of them say that Russia will pay. They do not specify how and when. We will try to clear some legal questions today with regard to reparation. But before we start, let's turn a bit to historical aspect. So how reparations were paid historically before Ukraine and Russian war?
That's a great question, Elena, and I'd like to start before I answer it by thanking you and Anna very much for the opportunity to speak with you today. Also, thanks to the Ukrainian Arbitration Association for the opportunity. It's an important issue. It's in some senses one of the most important issues facing the international legal community, and it's an honor to be able to contribute in this setting to addressing it. Historically, it depends a little bit how far one wants to go back in time to examine issues of reparations. Perhaps the most relevant time periods, though, would be in the 20th century, and perhaps to a lesser extent the 21st century. And you can see a variety of different mechanisms during those time periods for reparations, for compensating the victim of aggressive war, something that I think the international community has, without any question, concluded exists in the case of Ukraine, as part of an overall peace settlement. The World War I and the Versailles Accords, for better or for worse, were one example of the defeated powers being required as part of an ultimate peace settlement to make quite substantial reparations. There's a lively historical debate that I don't think we need to go into as to what the consequences of those reparations in that particular context were. But one obvious way of requiring reparations to be paid and creating a mechanism for that is as part of a peace treaty. The same thing existed in relation to the Second World War as well, although I think the obligations for reparations, particularly vis-a-vis the Western powers, as somewhat ironically, in contrast to the Soviet Union, the reparations were not terribly significant. Most of the reparations, again, as part of the ultimate peace accords in Potsdam came via the peace treaty and were principally focused on industrial equipment, machinery that was to be transferred either further west or in the vast majority of cases east. Very substantial amounts of German industrial capacity were taken by the Soviet Union as part of the peace treaty. The same thing happened to some extent with Japan as part of the peace agreements at the end of World War II. There were mechanisms for Japan to pay reparations, in particular to Southeast Asian states, not really to the United States, to the United Kingdom. But again, as part of a negotiated peace agreement, I mean, and one can debate how negotiated it really was, given the fairly unconditional surrenders. As part of the overall peace agreement, there was a mechanism with respect to both an obligation to pay reparations and amount of reparations, and at least at some level of detail, mechanisms for making sure that those reparations got paid. The fast forwarding a little bit, the Iraq and its invasion of Kuwait also involved a reparations mechanism. In this case, less a negotiated peace agreement, and instead the Security Council, UN Security Council resolution that both imposed substantive obligations on Iraq to compensate specified categories of states and individuals, entities, and also a mechanism for that to be done, the UN Compensation Commission. To some extent, it was a deliberate effort to do something different from the Iran-US Claims Tribunal, which sort of is in very, very broad terms comparable, but also different in important ways. It wasn't, although there had been hostilities between Iran and the United States, it wasn't a war in the sense that Iraq or the two world wars were, but there was a mechanism for settling claims on the two sides out of a specified body of assets. But the concept behind the Iraq UN Claims Commission was that one wanted a quite rapid mechanism for distributing assets, Iraqi assets, to those who had suffered most from its aggression. And in contrast to the more traditional arbitration mechanism that one saw in the Iran-US Claims Tribunal, one had more of a sort of claims processing mechanism without the sort of opportunity to be heard in the same way. There was still an opportunity to be heard, but in a much more expedited fashion, perhaps because the culpability of Iraq was so clear, and it was more a question of identifying quantum as opposed to assigning responsibility. I think what one can take away from those historical examples is that there's no fixed rule as to how reparations are to be paid. In a sense, it's a matter, we would say, in private law of contract, treaty, and different mechanisms can be set up in different contexts. Very importantly, though, I think what one is seeing today in respect of Russia is the international community doing perhaps not its utmost, but being more robust in its efforts to find mechanisms to ensure that reparations are paid. I suspect nobody is betting a whole lot on a peace treaty just at the moment that would include an obligation to pay reparations. Hence, I think states are looking at unilateral mechanisms, and we can come on and discuss this to some extent, unilateral mechanisms to identify and seize Russian assets, either state or individuals associated with the state in some fashion, and through some sort of national law mechanism, make those available to a category of victims, varying depending on the national legislation naturally. And I think also different countries learn from one another in different ways as part of this process, and one can expect there to be evolution and cross-fertilization of national laws. I suspect there will also be international mechanisms in which states, consistent with their obligations under the Articles of State Responsibility, Articles 41, 48, take steps together to create mechanisms by which reparations can be paid out of, can be assessed and paid out of an existing sort of body of assets. And we'll come on in a few minutes and talk a little bit about what that body might be. I think big picture though, it's a landscape in which there is a high degree of flexibility. Traditionally, peace treaties or UN Security Council resolutions were the orthodox way to do it. Those, for various reasons, may be difficult to accomplish at the moment for obvious reasons. But there are alternatives, and states are actively exploring those mechanisms consistent with their international obligations.
Thank you, Gary. You already started explaining that a peace agreement is one of the best options, of most organized options. But what Ukraine could do or shall do now or in future if there will not be a peace treaty, or if this treaty will not provide for any reparations?
And I think those are quite practical, quite important questions. One can certainly hope that there would be a peace treaty. A lot of things have to happen before that happens, I suspect. But one can certainly hope, and that would be a mechanism that required Russia's cooperation and participation. Would have some benefits. It would have some disadvantages also, obviously, but it would have some benefits. Assuming, Anna, as you say, that isn't possible, what can Ukraine do? I think what Ukraine can do is, to some extent, what it has been doing, keep pressure on its Western partners and other partners for that matter, to meet their international obligations to cooperate in remedying a violation of peremptory norms, use covenants, through concerted action, both at a national level and international level, to identify Russian assets and to make them available to Ukraine and Ukrainian entities. That means, to some extent, political action on the part of Ukraine to work with Western parties and underscore to them, and to some extent, I think this has been working. We'll talk to some extent about some draft legislation in the United States, Canada, elsewhere. But also, I think, to identify categories of entities, individuals, businesses, government ministries who have suffered particular loss, document that loss in a way similar to what's being done for war crimes, in order that if there is a mechanism that requires some level of proof along the lines of what one saw with the UN Crimes Compensation Commission, the proof will be there. It's obviously, fighting a war has priority, but insofar as there are resources available to record losses and identify victims, that's an important step.
And we've seen already with many investment arbitrations against Russia, and particularly UCAS, that Russia always resists enforcement, coming up with new theories, hiring the best experts, and even lobbying legislation. And in this conjuncture, how we can make Russia pay, how Ukraine make Russia pay the reparations?
So I think it probably makes sense to talk about a couple avenues. I personally think one of the most promising avenues is through national legislation in leading jurisdictions where there are significant amounts of Russian assets. That means the US, it means Canada, means the United Kingdom, but it also means other European states, Switzerland, perhaps non-European states. When I say Russian assets, when we say Russian assets, it's also important to think a little bit about what that means. I mean, it includes Russian state assets, it includes Russian state-owned company assets, but it also, of course, includes individuals, oligarchs associated with the current regime. And different national laws do and can be expected in the future to draw different lines with respect to those various categories of assets. One, in the sense, the most straightforward category in terms of culpability would be Russian state assets. Russia's responsible for the aggression. They're the ones who historically, World War II, World War I examples, the Iraq example would be the payer, the entity that's required to pay reparations. And so that's the most straightforward in terms of culpability. It obviously raises issues of state immunity, but many countries, the United States is a good example, would be able through their national legislation to lift immunity. There would be domestic constitutional issues as to taking the property and so forth, but without wanting to, spoiler alert, I guess, without wanting to spoil the outcome of future litigation, I suspect that constitutional challenges on the part of the Russian Federation to the seizure of Russian state property, whether central bank or otherwise, are unlikely ultimately to get much traction in the US judicial system. There are a number of arguments, including that foreign states are not persons protected by the Fifth Amendment takings clause, and that in any event, taking a property in these circumstances would be fully justified without compensation. I think it's more complicated, but nonetheless well worth pursuing to consider assets of state-owned companies and companies associated with the Russian military effort, Wagner, whatnot. So prima facie, it's difficult to see why assets of those entities ought not also be capable of being seized and used as part of an effort to ensure full reparations. There might, in different countries, be requirements for some sort of nexus or connection to the aggression. Companies that have nothing at all to do with the aggression, if they could demonstrate that, perhaps fall in a different category than companies that are fully engaged in either financing or implementing the aggression. But in the sense, those are details. Different countries could adopt slightly different approaches towards the exact scope of state-related assets that would be subject to forfeiture in a particular state, and following forfeiture, transfer to Ukrainian entities.
Maybe you've seen that Ukraine announced the seizure of property of Sberbank and Vneshekonombank Web in Ukraine, and just almost straight away Russian authorities started threatening new investment claims against Ukraine in this regard. Do you think that when Ukraine or this other state authorities will be trying to seize or to use this property to compensate Ukraine, Russia can initiate investment arbitrations, not only against Ukraine, but against the states?
So I think they'll clearly be able to initiate investment arbitrations. The question is whether they can win them. And I'm more skeptical on that count. One will obviously have to see how they put claims and what exactly the defenses under both customary international law, but also bilateral investment treaties or otherwise would be. But I suspect fairly strongly there'll be quite serious defenses to any such claim.
And coming back to the draft laws discussed already in the US or Canada, there are a number of factors actually related to the Ukrainian situation. And as I understand, one of the problems they are trying to solve is to do something with assets which are frozen according to different statutes, either economic sanction statutes or otherwise, because while they are under sanctions and while they are frozen, they are still below belong to Russian entities or individuals and could not be simply confiscated based on the existing legislation. And in different countries, there are different concepts of what exactly could be confiscated, yeah, and how exactly these funds could be used. And I know at least about 2 draft laws in Canada. This is Frozen Assets Repurposing Act and Budget Implementation Act, and at least about 4 draft laws in the US, Asset Seizure for Ukraine Reconstruction Act, two different acts, Oligarch Assets Forfeiture Act, and Ukrainian Sovereignty Act of 2022. Could you just briefly discuss what they are for and whether this could be a solution of our problem?
I'd be happy to, and it's quite important, I think, going back to some of my previous comments, to in fact focus on those legislative instruments. I think as a practical matter, they offer some of the most secure and reliable means of getting reparations in the near term, waiting for a peace treaty, waiting for UN Security Council, waiting for some sort of non-peace treaty, but other international instrument, all inevitably has the delays that any international agreement occasions. And so I think, oddly, since we're in the Ukrainian Arbitration Association format, oddly, it's a little bit like international arbitration, what countries are doing, namely, just as with the New York Convention, you enforce arbitral awards all around the world as a matter of national law under the umbrella of an international obligation, the New York Convention. I think to some extent the same thing is happening with reparations. There's an overall obligation, I would say, in Article 41 of the Articles on State Responsibility to cooperate, a mandatory obligation to cooperate using all lawful means to remedy the effects of violations of peremptory norms. And that's the umbrella, a little bit analogous, I would say, to the New York Convention, which individual countries then, and you give the examples of Canada and the United States quite rightly, then implement on a national basis using assets that are available in those countries. That has the huge benefit of actually being practical and pragmatic. There are assets in the US, there are assets in Canada. Assuming national law can get you there, you have your hands on those assets through government enforcement mechanisms, and I'll say in a moment what the legislation actually does. And you can then, through national law mechanisms, convert those assets from Russian assets into Ukrainian assets or the assets of Ukrainian entities via a reparations mechanism. In a sense, it's arguably premature to talk about the details of the Canadian legislation, because more accurately, it's proposed legislation. And the same is definitely true in the United States. Legislation has not yet been formally enacted, and although I believe it will be, it's not a certainty, and it certainly might be enacted in a different form than we currently see. Broadly speaking, both the Canadian legislation and the US legislation give government agencies the authority to seize, in terms of taking temporary or permanent ownership of a category broadly that we can broadly call Russian assets. That can include Russian state assets. It can, particularly in the case of the US legislation, include oligarch assets, and provided, and the legislation varies from one draft to another, but provided that the individuals are currently subject to sanctions and have some involvement with Putin's war of aggression. But assuming that those requirements of some sort of connection to the war of aggression are satisfied, and that they're either Russian or sanctioned Russian individual or entity assets, they can be frozen and also liquidated. The proceeds then being available for distribution to a list of categories of Ukrainian entities, and also in some of the legislation, non-Ukrainian entities. One of the recent U.S. statutes extends, I think, to all European entities, I think with an eye towards the Baltics and Poland and so forth, perhaps. But assuming that the legislation is adopted in something like its current form, there would be government authorities who, just as they have the power to take, bank accounts from drug dealers or illegal gambling cartels, they can take assets, bank accounts, villas, whatnot, from Russia and Russian oligarchs, freeze it, convert it into the property of the United States or some other US entity, and then liquidate it for the benefit of defined categories of Ukrainians and otherwise. That has the excellent benefit from a practical perspective of not requiring a whole lot of international discussions or agreement. The United States Congress enacts legislation, the United States executive branch enforces it, the United States courts make sure it works, and the money flows. It is not unprecedented. There are other examples of the United States doing that, although it's, this is an innovative step in many respects, given the magnitude and the breadth of the reparations.
And do you think in such situations they will need to wait, for instance, ICJ decision in genocide convention case? Because one of the claims filed by Ukraine regards concerns reparations to be paid by Russia. I understand that they are unrelated, but there are two questions. First, whether the US authorities would need some legal basis or this is just a discretion. And second, separate question, how exactly this decision of ICJ could be then enforced, because we all understand that most probably Russia will ignore the decision as it has already ignored the court order.
I think all that's well said. Answer to your first question is the United States doesn't need to wait for the ICJ. And if you look at cases like Medellin versus Texas, it's probably a good thing that the United States doesn't regard itself as needing to wait for the ICJ. From a US perspective, these are assets in the United States. If Russia wants to take action against the United States, either under investment treaties or Russian oligarchs want to take actions against the United States under investment treaties or otherwise, they're free to do so. But the United States can do what it will with these assets, including paying them to Ukrainian entities, irrespective of how the genocide convention case proceeds. It doesn't need authorization from the ICJ. It doesn't need to wait and see if the ICJ judgment might somehow be inconsistent with it. The ICJ judgment would at most require Russia to pay some sort of reparations. It wouldn't obligate the United States to do anything, so far as I can imagine. And therefore, no need to wait for the ICJ. I think, turning to your second question, that's probably also a good thing in the sense that, and I hope I'm wrong about this, but I think the scope of the Genocide Convention claim, damages arising from a false accusation of genocide, may not be as expansive as necessary to address the full scope of Ukrainian losses and damage. I suspect, I could be wrong about this, certainly, but I suspect that's a narrower definition of potential damages. I think there may nonetheless be scope for other claims in the ICJ against Russia. Convention for suppression of financing for terrorism, I think, has some quite interesting possibilities. when you think about all the sorts of financing that was necessary for this this war of aggression, and what the consequences of failing to have suppressed that financing, either by private Russian entities or, for that matter, by state entities, state budget figures. And I could well imagine if such a claim can be mounted, it would have much broader scope than genocide. But I continue to think, sort of circling back, I continue to think that there are substantial amounts of Russian assets in the hands of Western and other nations. Using those assets provides prompt and uncomplicated means of reparations, waiting for a peace treaty or Russian compliance with an ICJ judgment 2 or 3 years in the future doesn't offer those benefits in my view.
But do you think that Ukraine would be able to somehow enforce this judgment? I understand that the judgment does not oblige US or other jurisdiction to do anything, but if they hold any assets, Russian assets, yeah, already on a special account or otherwise, is it possible for Ukraine to go to that state and ask them to release that part of those funds in compliance with this decision?
So, I mean, that's a good question in the sense that it's a different look at the question of national legislation we were looking at, right? We were looking at sort of the US-Canadian examples where specialized legislation specifically tailored to the Russian-Ukraine conflict has been adopted, which allows, at least in the current drafts, reasonably prompt and pragmatic reparations. If you don't have that, there might nonetheless be possibilities of enforcing both ICJ judgments, but also, for that matter, Ukrainian or other national court judgments, not international tribunals, but national court judgments. The difficulty there is traditional notions of state immunity present significant obstacles to actually executing upon the assets. There may be scope in different countries for creative arguments about violations of peremptory norms and the consequences of that. I think I certainly don't want to say that those kinds of arguments couldn't ultimately succeed, but it is not straightforward, and it would take some hard lawyering, some creative lawyering to be able to enforce either ICJ or national court judgments, Ukrainian court judgments in other jurisdictions that don't have US-Canadian type legislation. It's possible that there could be amendments to state immunity acts that would facilitate those kinds of enforcement efforts. It's certainly a useful idea to pursue. I think persuading countries to adopt legislation along the lines of the US and Canadian model might be a more practical approach.
If you come back to the reparations and how they will be calculated, what do you think, how and who will determine the amount of reparations?
That's completely dependent on which forum out of all the various mechanisms we've discussed, right? I mean, if we're in the Iraqi model, you could imagine some kind of international tribunal equivalent of the UN Compensation Commission that would make those determinations. You've got to go through a bunch of steps to create and get functioning such an international tribunal. If you're in Canada or the United States, the answer is provided by those statutes that we've been, those legislative proposals that we've been discussing. And in them, the Canadian ones, I think, focus more on Canadian courts having authority to make specified determinations about the identity of the Russian asset holder and their complicity with human rights and other violations, and also to identify who would receive reparations. In the US, I think it is more executive branch officials would make those determinations.
And how many years do you think that, like, in best case scenario and worst case scenario, it can take to get the reparations?
Best case scenario, and it's always extraordinarily risky to predict almost anything, but especially legislative action. Best case scenario, these legislative proposals get adopted over the summer. Assets in many cases have already been frozen, and one could quite promptly move towards liquidation. Best case scenario, end of the year, I think is probably unlikely, but not inconceivable. There'll probably be litigation, constitutional and other challenges in the United States. But I do think that US courts will be mindful of the need for urgency here, the need to get money to victims before their lives are more completely destroyed. And thus, if there are serious constitutional challenges, those should get resolved reasonably promptly. Worst case scenario,
Never, but
your grandchildren's are still waiting for a peace treaty.
thank you, Gary. And when we look from the perspective, we already received the reparation, it's time to pay. Who should be the receiver? Is it just Ukraine as a state, or we look here also that physical and legal persons, individuals, can also get payment directly, not through the state?
It's a great question. And I guess there are a couple of ways to think about the answer. One would be to look at what's historically done, like the Iraqi example. And the other would be to look at the models that are contemplated by the US and Canadian legislation. The Iraqi example, the UN Compensation Commission allowed compensation to flow in particular to individuals and to businesses, as well as to the state. Indeed, I think, and I'd have to go back and check, but I think the lion's share of reparations compensation went to so-called private entities as opposed to the state. The US and the Canadian legislation give substantial discretion to either courts or executive officials to decide who should receive compensation. And it includes both state entities, the state, but also private entities. I think in this regard, there's also a good example from the Iran-US Claims Tribunal, which is worth keeping in mind. As you probably recall, the Iran-US Claims Tribunal was established to hear claims by Iran against the United States, but also, most importantly, perhaps in terms of number and size of claims, by US companies and individuals against Iran for the events that led up to the revolution and followed it, claims for expropriation of property, that sort of thing. A lot of those claims are what one would expect: major businesses that lost their factory or were completely expropriated, the sorts of things you would see in a bilateral investment treaty case. However, and importantly, part of the Iran-US claims mechanism was the facility on the part of the US State Department, equivalent of the Foreign Ministry, to bring a class of claims on behalf of individuals who had so-called small claims. I don't remember what what constituted small. And this was back in the 1980s. So whatever the number is might be a little bit misleading. But for our purposes, something less than $1 million US dollars or €1 million, something to that effect. And the US State Department could bring a whole bundle of those claims for individuals who lost their car, lost their house in Iran, lost their household possessions and so forth, things that they probably would never pursue because there wasn't enough money and they weren't sophisticated enough without some kind of class or group mechanism. U.S. State Department was able to pursue those claims, and substantial compensation flowed to those individuals. Not substantial in a sort of UGO sense, $50 billion, but substantial to the individuals. And when I see the pictures of Ukrainian elderly families picking through the remains of their homes and the damage that they suffered, the destruction to houses and to small businesses, the destruction in municipalities to roads or similar sorts of things. I think that kind of mechanism, a class mechanism for individuals, is highly important. Obviously, it's important that the Ukrainian state also receive just reparations. It's important that the major businesses do so as well, but we ought not to forget, for all kinds of reasons, the ordinary woman and man in the street who've, in a sense, borne the brunt of the suffering.
Thank you. Indeed, there is a question of private individuals and business in Ukraine, whether it's possible, in absence of any existing mechanism, and looking at this draft legislation in US and Canada, whether it would be able to pursue a claim there. I mean, if it's not has been somehow quantified in other fora, because as you just mentioned, both draft legislation contain a possibility not only for the state to receive some amounts, but also for the victims of the war. And it's not clear. So after reading, it's not clear whether they simply give this money, just they ask, and Ukrainians ask, and the authorities or the courts give, or it would be kind of proceeding a kind of litigation or enforcement of any quantified decision of other authorities.
So that's a great question there. I mean, it won't be a mechanism, I'm sure, in either the US or Canada or other countries where you just come and ask and you get money. There'll be some kind of filtering mechanism to ensure that there aren't false claims or exaggerations and so forth. There are models for that, at least in the US. The 9/11 sort of compensation mechanism and the oil spills in the Gulf of Mexico included quite significant mechanisms to figure out who suffered, how they could prove what they lost, and how they should be compensated. Those various things, those mechanisms to assess loss and causation and so forth, need to be tailored to the specificities of a particular case. It's one thing to do the Gulf of Mexico, which is in the United States. It's in the Americans' backyard in a sense. It's easy for them to get the proof and so forth. It may be more complicated, especially if the war goes on in the Ukraine. So there needs to be some mechanism. I think implicit in what you said, Elena, is if there were a Ukrainian mechanism that would do that in a reasonably reliable way, could you use that in the American or the US or the Canadian proceedings? I think the answer is probably yes. Perhaps not sort of automatic recognition. In a funny way, it's like a mini recognition of foreign judgments in a very specialized context, or recognition of foreign arbitral awards in a very specialized context. But I think, and I think that's what, I also think it's an area where communication between whoever the authorities are in Canada or the US on the one hand and Ukraine on the other would be valuable. If the Canadians are going to say, for example, we won't be satisfied unless there's been cross-examination of somebody claiming, then Ukrainians ought to make sure there's a cross-examination mechanism. That's just an example, and who knows what kind of issues might come up. But you could imagine a degree of bilateral cooperation whereby the authorities in the place where the evidence is, Ukraine, would do things to identify loss and quantify it in order to provide that to the authorities in the place where the money is, Canada or the United States.
Yeah, and here is very interesting question. So let's assume that Ukraine has provided some evidence of the damages suffered by Ukrainian entities and individuals. In fact, it has collected through some websites created specifically for that purpose,
like
information about damages. So the question is, so if, for instance, Ukraine files such, or not a file, files these documents as a proof of the quantum it seeks to receive, whether there is a need of any assignment on behalf of those private individuals for Ukraine to claim this amount,
yeah.
or connected questions, but vice versa. If Ukraine, for instance, gives some funds to victims of the war on the Ukrainian territories, could Ukraine ask to assign their title to claim some reparations or damages compensation from Russian Federation? And the same applies. So if any third institution like European Union gives us some money, whether they also could ask us, either Ukrainians or Ukraine as a state, to assign some portion of our claims to them.
Yeah, I think the answer, those are excellent and far-sighted questions, and I think the answer is in all likelihood going back to what we said about the flexibility and sort of contractual character of reparations historically, is that you could come up with various of the mechanisms that you've described. You don't necessarily have to. There's no requirement. I don't think there's any international legal requirement that you do any one of those things or all of them, but you could well imagine sort of any or all of them being adopted either as requirements by the United States. They might say, the only way we're going to recognize claims by small Ukrainian businesses is if the Ukrainian state has validated them and presented them. Not saying that the US would do that, but you could imagine just to make things more efficient and to avoid abuse of the system, you could imagine a requirement like that. There's no reason that would be necessary. You could also imagine the United States saying, no, individual claimants can bring this if they wish, and will also permit, consistent with usual US litigation procedures, class actions by the small claimants that I referred to. I really do think sort of those questions about who brings the claim, in what capacity, does there need to be an assignment, depend on future specifics that we don't know quite yet. It might be worth thinking about what the legislation currently requires or sort of might require, just to avoid complications in the future.
Yeah, and probably last clarification regarding, so we all understand that there could be different fora with different participants, but what could be the basis for awarding reparations? So should it be the treaty or national laws, or just the fact of damages caused by Russian Federation on Ukrainian territory after the Russian invasion?
So I think it depends on the forum, right? If you're in the ICJ, it needs to be violation of a treaty or customary international law as to which Russia and Ukraine have consented to the ICJ's jurisdiction. ICJ is not going to award reparations, I don't think, based on national law. On the other hand, if you're under the US or the Canadian legislation, you don't need to show a treaty violation. All you need to show is whatever the statute requires. And as we discussed 15 minutes ago or so, the statutes are quite broadly drafted. They let you seize any assets of the Russian state entities, and sanction Russian individuals and oligarchs, and lets those assets then be given to entities that has suffered as a consequence of the Russian military activities. The precise statutory formula varies from one law to another, and who knows what it will ultimately be. But I suspect it won't be very complicated, and in particular won't require any showing of a violation of international law. It's instead the United States saying, we as a matter of national legislative policy think it is the right thing to do to take assets away from Russia and give them to entities in Ukraine that have suffered loss because of the Russian military activities. It's a national law formula that doesn't require the showing of a breach of international law on the part of Russia. I think obviously such a showing could be made, but you don't need to make it for purposes of this legislation. Russia may, at some point in the future, already has indicated it will, complain about what the United States, Canada, others do, and they can have that discussion on a diplomatic level, and they can attempt to assert claims against the United States for its own violations of alleged violations of international law. I think those will be tough arguments given the scope for countermeasures under the articles on state responsibility, but Russia's free to assert whatever claims it wants.
Thank you, Gary. I understand that we don't have questions from our audience. So I wanted to thank you joining us today and for supporting Ukraine. We really hope that we will live the days when we will see Ukraine victory and Ukraine being rebuilt as a new modern country. Traditionally, I also want to say Slava Ukraini, glory to Ukraine. We are already working on our next webinar, so please follow our activities and join us. Thank you.
Thank you both.
Thank you very much.
Thanks so much.